Welcome to this learning series about the citizen and the democracy by the Shalom Hartman Institute. I'm Elana Stein, Director of Faculty and Scholar in Residence for Shalom Hartman North America, and I'm going to discuss personal virtue, integrity, and responsibility as key aspects of citizenship. While the rabbis of the Talmud have many ways of talking about this issue, we're going to focus on two: going above and beyond the letter of the law, and what it means to suggest that there's such a thing as the laws of heaven and not just the laws of human courts. There's a lesson that I've learned very deeply in this pandemic, and that is how interdependent we all are. What my neighbor chooses to do, what other parents at my child's school choose to do or not to do, it's going to impact me. Not only are we interdependent, but we are unable to enforce what it is that we hope that others will do for us. While it is possible for private institutions to make sure that people walk in with masks, and it is possible to fine people for not doing the right thing, it is actually impossible to force a person to actually disclose symptoms that they may have when they come in contact with other people. There are many aspects of that that are deeply disturbing. And yet at the same time, the role of personal responsibility as being distinct from law, I think, is significant. I want to look at two rabbinic concepts that discuss the importance of personal responsibility as distinct from law, but related to it. The first is an idea that's known in Hebrew as lifnim mishurat hadin, within the line of the law. Now, usually people explain that to mean going above and beyond the letter of the law. But actually, the wording itself, as Professor Christine Hayes points out, the wording itself means that you're staying within the line of the law. What the rabbis mean by that is that sometimes the law will let you go to a certain point to claim your rights, to claim exemptions, to claim what it is you feel is coming to you or you should not have to do. And yet there are times when we would ask people to say, you know what, don't go all the way to what the law would allow for you. Stay within it. Pull back a little bit. Don't always claim everything that is coming to you. Some examples that come up in the Talmud. One example that may surprise you is actually an example of a money changer who's supposed to give people coins that they can use in the market. And one of the customers finds out that the coin that they've been given is actually not usable. She tries to use it at market and they won't accept it. She goes back to the money changer and she says to him, you know, you gave me a coin that really doesn't work. Now, in this instance, he says to her, look, I did everything right. I did my due diligence. It's just that the rules changed at a moment that I wasn't aware and I couldn't have necessarily been aware of. I did what I was supposed to do. And yet in that instance, he says, you know, let's write this up as I made a bad transaction. You take the money, a new coin that maybe you can use at market. Or another example, day laborers who break something that belongs to their employer. And they say, please don't take it out of our salaries. We won't have enough food to eat. And the employer is told, don't take it out of their salaries. That's the virtue. That's the way to act. You can afford it, and it's something that you can do. Now, in these instances, what we're talking about is we're talking about personal responsibility that's really about generosity. You didn't do anything wrong. And yet, because you want to have good character, a generous character, you decide, I'm going to be a big person here, and I'm going to give up something of mine. And in fact, the rabbis aren't content to leave this just up to our personal decision making, but they want to hitch it They want to connect it not only to Torah, but they want to connect it to the legal system in some way. They use a verse from the Torah in Exodus chapter 18, Shmot, Perek Yud Chet, in which Moshe is going to appoint other judges besides himself. His father-in-law Yitro, his father-in-law Jethro said to him, no, you can't do this all on your own. You need help. He's supposed to appoint judges, and when he appoints those judges, he's supposed to tell them lots of things. He's supposed to teach them the law. He's supposed to train them. Part of that training, the verse says, is you're going to teach them et ha'ma'aseh asher ya'asun, the action that they will do. Now, extraneous phrase. You teach them the laws, teach them the rules. The action that they will do, what is that? The rabbis use this clause as an opportunity to say, you know what et ha'ma'aseh asher ya'asun is? The action that they will do. This refers to going beyond the letter of the law or within the line of the law. Train these judges, train these judges to know that they should go within the letter of the law sometimes. Now, this is very complicated. The idea that you can actually entrench generosity, personal responsibility within the legal system itself, it's complicated, and we'll get back to it. And yet, the Gemara in Bava Metzia 30b says the following. Rabbi Yochanan says, Jerusalem was destroyed because they adjudicated cases on the basis of Torah law in the city. And the Gemara says, what do you mean? Jerusalem and the temple were destroyed? What else should they have used to adjudicate cases? Should they have adjudicated cases based on arbitrary decisions? Instead, the Gemara says, let's explain what Rabbi Yochanan meant as the following. The problem is that they established their ruling on the basis of Torah law, and they never went beyond the letter of the law or within the line of the law. A society that doesn't know of the significance of generosity is going to be in deep trouble. The idea that law is enough to get us where we need to go as citizens, as members of a collective, it's going to fall flat on its face if we're trying to create a society of generosity and not just of let's do the least that we can. That's concept number one. And we'll return to it. We'll return to the problematic and the aspiration of including going beyond the letter of the law within the law itself. But the second concept that I want to talk about is a concept known as Dinei Shamayim, the laws of heaven. The rabbis posit that when you walk into a courtroom, you might think that you are only being judged by a human court, but actually you are being judged by a divine court as well. And so there are instances in which the human court cannot prosecute you. And we'll talk about those instances. But the divine court has your number, and the divine court is still watching, and that matters. These examples tend not to be about generosity and going above and beyond, where you're really not culpable at all. They tend to be about situations in which I am culpable, but not in a way that I can be prosecuted in a legal court. So I'll give an example. One example would be if I passed by a pen where an animal was that didn't belong to me. And I saw that the fence that is holding in the animal, it's a matter of hours, it's a matter of days before the fence falls down of its own accord. It's not in good shape. And you know what I do? I breach the fence. I break the fence. So I speed up a process that was likely to happen anyway. Either the animal gets lost or the animal goes and damages someone else's property. And honestly, by rabbinic rules, in a court of law, there is a possibility that they wouldn't be able to prosecute me. It was going to happen anyway. My place in it is too indirect. I didn't send the animal off to do damage. I didn't push the animal out of its stall. I was involved in something that was going to happen with or without me. So there's my excuse. I'll give another example. I know some testimony for someone else that could help them in a case where they're trying to retrieve money. And I just say to myself, I'm a witness by myself. It's not like I have a second witness with me. So I don't think I'm going to go to court. I'm just not going to go. The plaintiff loses their case. Now, I knew something. Granted, in a Jewish court, you need 2 witnesses in order to get something done that's official, that's going to take money from the other person, from the defendant. But having 1 witness would have caused the defendant to have to take an oath and swear that they didn't owe any money. And that's pretty serious. Maybe that defendant would have said, I'm not going to swear because I'm lying and I'll give the money back. But I say to myself, is it worth it? Do I need to do it? Isn't it possible that the defendant will just perjure themselves? Why should I even bother? There's an excuse there. And the rabbis say, we may not be able to prosecute you in a court of law, but God's watching. God knows what you did. And you didn't do something right here. You did something wrong. You have some excuses, but those excuses basically amount to not enough to not feel guilty or to not assume some sense of guilt that you could have done something to make the situation better, and instead you did something to make the situation worse. In cases of Dinei Shamayim, in cases of the laws of heaven, we're often not just talking about personal virtue, of what's your character. Often what we're talking about is what's going to lead to a healthy society. What is the point of having a court system that is based on the testimony of witnesses if people just choose not to show up? What is the point of having laws about damages and about paying money when somebody's things are damaged or lost or destroyed, if people can figure out a way to damage other people's property with impunity? What's the point of having civil law at all if people can just undermine it by being clever? And so the rabbis suggest, hold on, you're not off the hook. We can't prosecute you, but have a conscience. And in fact, some of the later commentators, notably Nachmanides, suggest that having a conscience is actionable in the court. They're not going to be able to force you to pay your compensation to make up for what you did. But they can say, we don't want you as a witness in our court. They can say, you are persona non grata in the court because you're a person who essentially facilitated theft. Someone was owed money, and because of you, they're not going to get it. And you were involved in the loss of that money. And so this second notion is also connected to law, but it's still separate from law. So here we have these 2 ideas, 2 rabbinic concepts of many. One that seems to be about personal character, virtue, generosity, choosing to take on loss, even though I'm really not responsible. And the other being about the importance of maintaining a system of civil society where people take responsibility because they are somehow responsible, but in ways that we may not be able to enforce. These two, I'd like to argue, are key to the notion of citizenship. One is about the privacy of who I am. Another is the gestalt of what kind of society we want to make together. I want to end by thinking a little bit more about the question of how this all relates to law and legal systems. The reason I want to think about that is really because I think there's been a lot of disagreement in this country over what personal responsibility should entail. And I understand that disagreement because it's kind of natural. When you take something out of the bounds of law, you're going to get personal disagreement. Even in law, you're going to get disagreement, but at least then you have procedures for deciding what's right. The case is as follows. In 1977, the Supreme Court of Israel decided on a case in which an employee who had a gun as part of his job, he used that gun to kill someone. The family of the victim was suing the corporation that that man worked for, who gave him the gun, and saying, you owe us damages because you should have seen to it that that gun was not misused, and maybe that that gun was left at the office at the end of the day. The justices who oversaw this case had deep disagreement about what to do. And I want to read this disagreement because it cuts at the heart of what we're trying to talk about here. The first opinion that I want to share with you is the opinion of Justice Menachem Elon. Now, Menachem Elon was known for bringing in Jewish law to his rulings in the court. And so let's read what he says. He elides somewhat the two categories that we've spoken about here. One being about Dinei Shamayim, the laws of heaven, and the other being about Lifnei Mishurat Hadin, taking on more than what the law requires of you, or not claiming your full rights in the law. He writes as follows. It is a Jewish tradition and a fundamental principle in Jewish law that along with strict legal liability, there is an additional obligation to act Lifnei Mishurat Hadin, within the line of the law. It is of particular significance here that this obligation found one of its chief expressions in Jewish law in the field of torts, in a case precisely in point with the instant case. He essentially is including as well the laws of Dinei Shamayim, the laws of heaven, which come up in context of damages, as one of the examples that we mentioned. Under the current legal system, he writes, we cannot force a person to act beyond the letter of the law. It is up to the initiative and goodwill of the litigant. But it appears to me that under certain circumstances, it is appropriate for the sitting judge to make a suggestion. I myself would exhort the vindicated party to behave in a manner beyond the letter of the law and compensate the claimant as she originally intended, so that she can fulfill the instructions of our sages, so that you should walk on the path of goodness and preserve the ways of the wise, the source of the principle of going beyond the letter of the law. Now, what Justice Elon does here is he says, I can't force you to pay damages. After all, your involvement is indirect, but you should pay damages. I want to be a moral authority here, even if I can't be a legal authority here. Morality is important, and we can't shirk it in the name of non-enforceability. Justice Mayor Shamgar, who was later the head of the Supreme Court, actually disagreed with Elana. Not on the idea that they should pay, but on the idea that justice should actually be discussing it. I strongly dissent, he writes, from the objective revealed between the lines of the opinion of my distinguished colleague that seeks to elevate payment of compensation lifnim mishurat hadin, within the line of the law, to the status of a settled general principle of the law of torts. Such an approach will necessarily bring about the filing of frivolous appeals. My concern here is not for the time of the court, but for the resulting consequence, namely the adverse effect on those appellants whose appeals have merit and who will have to wait even longer for a decision in their cases. His first argument is basically, this is a bad idea. Don't talk about lifnim mishurat hadin. Don't talk about going within the line of the law in a courtroom. What you're going to do is you are going to open up a situation in which every person is going to bring their case in the hopes of getting a justice to say, within the letter of the law, beyond the letter of the law, you should be able to get what you're asking for. And that will end up creating a situation in which those who really are within the bounds of what the law requires will not have their voices heard, their cases heard. But his second point, I think, is even more interesting. He writes, moreover, a legal system that deliberately chooses to abandon the boundary lines marked out in the substantive law and to add as an additional and alternative stratum and as an established part of the system a recommendation for the payment of compensation beyond what the law requires necessarily acts according to impossibly vague standards, which ultimately depend on the fortuity of which particular judge sits when the case is reached. Such a system will, over the course of time, bring about confusion in the law and adversely affect the rights of the parties. The absence of clear standards may also often actually produce inconsistent results. Shamgar, in his second argument, says, well, I have a different problem, which is it's not just about taking up the time of the court with things that aren't about the substantive law, but suggesting that we come up with a standard for lifnim mishurat hadin, going above and beyond, suggesting that we come up with a standard that is about dinei shamayim and the laws of heaven, and that we bring it into the courtroom. That actually is going to lead to a lot of ambiguity. Because how do we decide if this is a case where somebody should be acting lifnim mishurat hadin, or that there are dinei shamayim involved? And how do we decide if it isn't? And if that's the case, and you don't have actual procedures for figuring out when these apply, but instead it's really up to the justice themselves to suggest what they think, we're going to be in a situation of impossibly vague standards. I love this argument. The reason I love this argument is because I can feel both sides of it. On the one hand, living in a situation in which other people's personal responsibility matters to me greatly, and I want it to be enforceable, I want there to be moral voices out there that push for this as an ethic of citizenship, right alongside paying taxes, right alongside voting, right alongside keeping the law. And yet I know, and I've seen the contentiousness or contention that comes up around issues that are not settled law, that don't have a clear procedure, that don't have clear basis. And so I'm left with this question. How do we encourage ourselves and encourage other people to think deeply about what it means to be a person of virtue as a citizen, what it means to create a culture of virtue in which people do not make excuses in order to get themselves out of things, but maybe they make excuses to try to help other people. How do we do that? And I think what this shows us, and even the argument between Shamgar and Elon, as much as Elon brings this into the courtroom, Shamgar is right. This isn't something that the courts are going to be able to teach us. This isn't something that is going to be about enforcement from the outside. It has to be something that's going to come from an internal compass. It has to be something that's going to come from care for the person next door. That's something that is about education, not just enforcement. So, in conclusion, what we've seen here is we've seen two concepts among many from the rabbis that relate to citizenship. These two concepts both rely on things that are unenforceable. One of the concepts focuses more on a person's individual character. The other concept seems to focus more on developing a system that has character and is effective, a society that has character and is effective. But one thing is for sure, what Elon and Shamgar tell us is that we cannot rely on enforcement for this kind of moral education. We actually have to rely on education. And what are we doing, each of us, to educate ourselves, not only to educate others, to reflect upon ourselves, not only to reflect upon others, about the ways in which we are not being as generous as we should be or as we could be, about the ways in which we are not taking responsibility for things for which we are accountable in ways that we'd rather shrug off or make excuses for. My blessing to us is that we all do this work together and that we see a society that has a deeper conscience as a result.